Now, starting with Lori Vallow Daybell, she wanted to have the Judge Justin Boreski, removed from all of her stuff. So that would be the Arizona stuff with the murder of Charles Vallow, which she's already been convicted for. And then also for the attempted murder of Brandon Boudreaux, which is going to be happening next week. Apparently, they're going to do jury selection. It probably already started already, to be honest. And then they're going to continue on to Friday. And then hopefully the trial will start on Monday. And yes, she will be representing herself again. Why? She's bored. I don't know why. Is she competent to do it? Yeah, they found her competent to do it, but is she truly competent to do it? Not mentally competent, but competent in other terms. No, I just feel like, in the trial with the Arizona one with Charles Vallow's murder, it was a shit show. So I'm expecting it to be a shit show again. Now, Lori Vallow had a hearing, a pretrial hearing about a week or two ago, where she started getting so frustrated with the judge that she's like, Judge, I'm going to ask you to recuse yourself. And the judge is trying so hard to be calm and cool with her because Lori Vallow is the type of person who is hard-headed. She's not really the most smartest person sometimes, but she thinks she is. She acts like she is. And it's hard to get through to her at some point. And she's the type of person who just goes off her emotions, in my opinion. That's how I saw it in the previous trial that we watched. Now, she again wanted to have the judge removed from himself from all of her cases, and they actually had a hearing today that was I don't think anyone even knew about it, but she did a hearing in front of a different judge and her motion was denied. So Judge Boreski is going to continue being on all of her cases in Arizona, and also the upcoming attempted murder trial that's going to happen next week, which we are going to be live streaming, and they are going to be doing a 30-minute delay, which they have been for the previous trial, which I actually kind of prefer that because there's live tweeters in the courtroom. So I get to know 30 minutes ahead of time what's going to happen before it happens. And I kind of like the spoilers. I know some people are like, oh, no spoilers and all that stuff, but I kind of like the spoilers. Let's hop on over to Lori Vallow. We listened to Lori Vallow making her arguments earlier, but it was just 2 minutes long. This one is 11 minutes. Let's see what happens.
20012420001. This is State versus Lori Daybell. Appearances, please.
Trina Kay on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Daybell for the defense.
I'm Pamela Hicks, Advisory Council.
Thank you. There was this got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we...
Lori Vallow's kind of quiet. Could barely hear her. Well, she does get animated later on when she talks about the judge.
would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Boreski from.
Who is this judge? It's a different judge. So this is Judge Jennifer Green, who's going to be deciding whether or not she's going to grant Lori Vallow's motion. Spoiler alert, she denies it.
Cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Boreski can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Okay. I did file this motion in this.
I'm sorry, can you pull the microphone? I'm sorry, can you hear me?
Sorry.
So even though this is all pixelated, we have the judge on the left side, maybe the head of the court reporter on the middle. We have Trina Kay on the right side, who's a state prosecutor. And then we have Lori Vallow and maybe her legal consultant. I don't know what that thing is on the right side. Maybe it's people joining via chat or something. I don't know. This is so blurry, so pixelated. It looks like Minecraft characters, okay?
I did file this motion and this affidavit after several attempts to. I made an oral motion with Judge Bresky and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from the state that I was comparing myself to biblical prophets, which I absolutely was not doing, and I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself.
No baby voice today. Yeah, we got Lori's real voice, okay, because she's fucking pissed. Usually the baby voice happens when she's like trying to act all cutesy, you know, and maybe because the judge is a woman judge and she knows it's not going to fly, possibly. I don't know. But yeah, this is her real voice right here. We don't need to baby it up.
From this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
All right, anything else? Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Bresky applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions that the state has won have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Bresky from this case.
Thank you. Ms. Dabo, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Bresky, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, you know, as I find out what we don't have and I ask for it, I'm continually, even to last week.
I mean, it doesn't surprise me that if you don't know what you're doing and if you don't understand the process, the law, that you think everything is unfair towards you because you don't understand it to begin with. I think that's where we're getting at. Oh yeah, here comes the baby voice.
Getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Bresky for these items for a year and a half, and I'm getting them 1 week before trial.
Meanwhile, she was trying to get discovery in late past the discovery deadline, and the judge asked her, okay, so what's the relevance of these people's testimony, or why do you want them to be a part of the trial? And she's like, well, we're not sure yet. We need to figure it out. Like, we need to. And he's like, okay, well, you're well past the discovery deadline. I will keep an open mind. It's most likely not going to be included. But remember how she wanted her discovery to come in late as well? And when the judge asked her what was the relevance, she couldn't give the fucking answer to it.
We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome that they would put an armed guard in the back. And because of the media that Judge Boreski has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me, and all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations.
No, he did not say before deliberations. Why are we just rewriting the truth here? He said that after they were released, after the verdict and after they were released, you know how usually like, okay, you guys are released now, do whatever the fuck you want. That's when they start looking at Lori Vallow and they found that she had prior convictions.
And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he...
Wait, he took back what he said?
So I'm not going to give you a new trial. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Boreski, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible. Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Boreski's substantive legal rulings.
That's what I said. I said, you can't accuse a judge of being prejudiced or biased against you just because you disagree with their rulings. Well, let's see what she says.
Is not a valid basis under Rule 10.1 to grant your motion and give you a new judge.
Oh, I wish I could see Laura's face right now. She just looks like fucking Minecraft. Can we see anything? We got anything? I don't think we got it. No. Okay, no. It's just pixelated.
The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial, unless there's some other allegation of bias that's been demonstrated. I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel. But the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have. If you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal...
I'm sure she'll do it. I'm sure she will.
Remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated.
Comparing her to the what's it called, the religious entity or whatever the fuck it was. Man, I'm really sad though, because usually when we have cameras on Lori, it's always the back of her head. This is the one time where we could actually see Lori's face, but we don't see Lori's face because the quality is so shit.
That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial.
Right. The state objected, and he ruled in favor of Lori and let her continue her questioning when he made that comment.
On this case. All right. So I'm denying the request to disqualify Judge Boreski under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you. We are adjourned.
Oh, she's pissed. She's pissed. So this Lori Vallow's motion to disqualify the judge, the Honorable Judge Justin Boreski. Defendant Lori N. Daybell files with this motion in her affidavit as required by, that's a long one, U.S. 28, California, Section 144, to show that the Honorable Judge Boreski has a personal bias or prejudice against her. As a result, the defendant cannot receive a fair or impartial hearing or trial before this court. Based on this affidavit, the defendant respectfully moves the Honorable Justin Boreski proceed no further this action and that another judge be assigned to hear this case. You know who also put in a motion to dismiss the judge? Donna Adelson. So if you guys haven't seen the Donna Adelson video, that's my most recent video that I have right now that I posted about a week or so ago. Go check that out later on, because Donna Adelson also wanted to have that judge removed. And she was also saying the judge was biased and that he was secretly meeting with the prosecution and they were investigating into whether or not Donna and Harvey were trying to witness tamper and bribe the witnesses as well. I, Lori Daybell, being duly sworn, say, Mrs. Daybell has made multiple motions for Justin Boreski, Judge Justin Boreski, to recuse himself from her cases. He has refused to recuse himself, knowingly and willingly violated the Code of Judicial Conduct, manifesting bias, prejudice, and cannot be impartial to the defendant's cases. Now, we watched the Arizona trial of the murder of Charles Vallow, and the judge was being very patient with her, in my opinion. There were times where he was getting annoyed, and you could visibly see it on the judge's face, in my opinion, but I think he was trying to make sure that he was moving slowly for Lori, because, you know, it's hard for her to represent herself when she's never been an attorney before, when she's never gone to law school. So her trying to do it on the fly for the first time, like, yeah, everyone has to be patient with her. Even the state was trying to move slowly and be patient with her. So I would say the judge is pretty darn patient. May 14, 2025, defendants' cases are in the worldwide media networks. Why does that sound like a Sarah Boone thing? Worldwide media networks. If only Sarah Boone knew about this kind of motion. Did Sarah Boone never do that? You're right. I don't think Sarah Boone ever made a motion to remove the judge. Hey, Karangal, how are you doing today? Lori has no idea how good the judge in prosecution is. He always explains things to her, which many judges will not, and if done, can be seen as biased by prosecution. They just want to make sure that there's no issues for appeals, and they want to make sure that, you know, things are moved in a way that Lori can understand and she can not complain about it later on. But you know how it is. You know, sometimes people just be complaining no matter what. On May 14, 2025, so that was a couple weeks ago, the defendant's case are in the worldwide media networks. Judge Boreski refused to recuse himself in direct questioning by the defendant. Yeah, because she started going after him. The judge proceeded to breach his duties of Codes of Judicial Conduct Canon 1-2 by further commenting with opinions of defendants prior to groups of counsel, the defendant's advisory counsel, and the defendant's motion that he has denied. Okay, here's the thing. Lori Vallow accused the judge of never ever granting any of her motions, of never ever granting any of the motions that were filed by her former defense attorneys as well. And the judge was like, no, that's not true. Actually, you just had a motion for, I forgot what it was, and I just granted it this morning. And she's like, well, besides that, he's like, well, I've granted some other motions from your previous counsels, and I've denied a lot of them because I think it was because, I forgot what was the exact phrasing that the judge used, but I think there wasn't enough law to back it up or something like that. So now Lori's trying to say that, oh, wow, that's bias. Hey, Diane, how are you doing today? Hello. Sherry, I felt that the judge was quite fair over her shenanigans. Yeah. Okay, so she was commenting on defendant's prior counsels, defendant's advisory counsel, and defendant's motion that he has denied without cause or decision to support his denial of request. A judge should have recused himself related to the merits of its own ruling. In regards to the complaint of judicial misconduct, a judge commits errors of laws in the process of reaching discretionary conclusions is abuse of discretion. On May 14, 2025, court proceeding, Judge Boreski behavior and judicial acts fall within the scope of bad faith. The acts were intentionally committed, and the judge knew or should have known that his actions were beyond a judge's lawful power and without lawful power of judge, but for corrupt purpose, which includes any other than faithful discharge of judicial duty. In Judge Carroll v. Commission on Judicial Conduct or otherwise committed acts deserving discipline. The motions that the defendant's prior two legal counsel's teams, the defendant and her current advisory counsel, have advised for the defendant to file for evidence and further motions of request are crucial to defense preparation, witnesses, experts, evidence, proof of innocence, cross-examination, rebuttal, and foundation to the defense, all of which Judge Boreski has deprived Lori Vallow of access to the evidence. A judge abuses discretion controlling discovery. Judge Boreski crossed the line of neutrality when he misemployed his powers when he assumed role using his judicial powers to advantage or disadvantage a party unfairly, thus giving impression that this court has opinion. Improper judicial intervention results in prejudice. The facial expressions, the attitude, the demeanor, and statement deprive the defendant of fair and impartial hearing. In conduct that is prejudicial to the administration of justice. The fact that I can't zoom into this makes it really hard to read this because the font is kind of small. So I'm struggling a little bit, guys, just a little bit here. Lori's excuse, Chad would never say no to me. Yeah, Judge Justin Boreski, not only is he not Chad, but he's also a zombie probably. Oh, speaking of zombies, you know what I'm watching right now in 48 hours? The home renovation homicide, because you guys were telling me about it a couple months ago and I was always on my to watch list. So I finally started it and I forgot that the TV show is called Zombie Home Renovations or some shit like that. I wonder if Lori be down to watch the TV show. It's got zombies in it, She liking them zombies. On May 14, Judge Boreski refused to apply or understand the direct guidelines of the Maricopa County Sheriff's Office own attorney, Maricopa County's Attorney's Office Civil Attorney Joseph Vigil. Wow, that was quite a mouthful. On March 20, 2025, Maricopa County Sheriff's Office responds to remove restraints during trial on page 3. Without any restraints in the courtroom, MCSO would recommend an unarmed detention officer and armed sheriff's deputy in the courtroom. The belt is visible in the defendant and has fallen off the defendant in prior trial proceedings. The motion was denied by Judge Boreski. Oh, I remember Lori was arguing with the judge saying, well, the sheriff's office, they actually recommended me to remove the restraints. And he's like, no, you're reading that incorrectly. It doesn't mean that they're recommending you to remove the restraints. It means that if you don't have restraints, then we would recommend X, Y, and Z. And apparently, I think there was a time where the belt was showing, apparently, during the Charles Vallow murder trial. But I don't know. I don't remember seeing it. Did you guys see it? Lori's so zombie focused. No love for the vampires. Don't bring vampires in here. Okay, that's like Letitia Stout's territory. Vampires, Did she talk about werewolves or was it just vampire focus? Did Shabusiness also focus on vampires as well? For some reason, my is in my brain. Under the Sixth Amendment, jurors glimpse a defendant in restraints can rise to a level of due process violations. Oh, and also I think the judge said that he doesn't even think that the jury saw. And she's like, well, how would you know the jury didn't see? Did you poll them? He's like, well, you didn't ask them to poll. You didn't ask the jury to be polled. So it's like, ooh, man. And Lori I don't think she had anything to say in response to that. I think she kind of just shut her mouth. Hey, just be nice. How are you doing today? Only Letitia was like, to meet Edward Cullen. Yeah, it was Edward Cullen, wasn't it? Ooh, Letitia. Under the Sixth Amendment, jurors glimpse the defendant's restraints can rise to a level of due process violation. A person subjects another to that deprivation of constitutional right within the meaning of Section 42 USCA Section 1983. If he or she does an affirmative act, participate in another affirmative act, or admits to perform an act in which he or she is legally required to that causes deprivation, anyone causing any citizen to be subjected to any constitutional deprivation is also liable. The requisite causal connection can be established by a series of acts in which the actor inflicted the constitutional injuries and abuse of discretion. Judge Boreski's denial of both Maricopa's County Sheriff's Office and Maricopa County's Attorney's Office Civil Attorney Mr. Vigil's recommendation and the defendant's motion for removal of restraint belt. The defendant is pro per, filed May 10, 2025, and denied by Judge Boreski. Hey, Crosby, thank you so much for the tier 2 sub for 83 months. Hello. How are you? How was your week? Fantastic. Love your channel. Oh, thank you. I appreciate that. There was a very snarky back and forth with, you didn't ask to poll them. I enjoyed that exchange so much. Yeah. Poor judge. On May 14, 2025, Judge Boreski denied defendant's motion to dismiss for abuse of discretion by Judge Justin Boreski, filed on April 26, 2025, for a violation of Speedy Trial Act. I remember we read this, was it in a live stream? So the reason why the speedy trial thing, the trial was delayed for a couple of weeks, not by a lot. It was just by a couple of weeks, but it wasn't just. There was like reasons for it to be delayed. Like it was like scheduling issues with the state, I think, maybe with the court as well. But they didn't think it was enough that would be prejudicial to Lori Vallow. Under 18 U.S.C.I. resulted in miscarriage of justice, failure to make prescribed findings to justify ends of justice. Continuance cannot be excused as harmless error under the Speedy Trial Act. Like, for example, if she was supposed to get speedy trial within, let's say like it was supposed to be before the end of May, right? And then it was like 5, 6, a year later that she would have her trial, then yeah, that's like pretty fucked. But it was only by a couple of weeks. The Sixth Amendment right to speedy trial, Congress enacted the Speedy Trial Act, STA, which criminal trials must commence. Under 18 U.S.C.A. Section 3161, the Speedy Trial Act and the case law are silent as to what non-statutory factor district court should generally consider. A court abuses its discretion when it fails to consider all factors relevant to the choice, and the factors it did rely on were unsupported by facts under 16 ARS Rules of Criminal Procedure, Rule 8.6, denial of speedy trial. If the rules have been violated, the court must dismiss the prosecution with or without prejudice. Violating the speedy trial rule does not violate the spirit of rule and the fact the defendant is deprived of due process. Like I said, I think it was only delayed by a couple of weeks, like 2 or 3 weeks or something like that. Hi, hey Shaniqua, how are you doing today? How's it going? Hello. Candace, it was delayed a little because they thought Charles' trial would take a little bit longer and the two couldn't overlap. Oh, possibly. Hey, Candace, how are you doing today? The state and Judge Boreski failed with end of justice for continuance. Judge Boreski therefore violated the Speedy Trial Act with failure to justify a continuance. May 11, 2025 was a Speedy Trial Act limit of timeline for a trial. Judge Boreski violated this rules of criminal procedure conduct. This was motivated by bad faith. Jimenez v. Judge Chavez. Reversed, remastered in Maricopa County. The speedy trial clock has exceeded the maximum days. The act is violated. Thus, the case should be dismissed. Dismissal without prejudice is not a toothless sanction for a speedy trial act violation. Here's a case. They said the court failed to request findings to justify ends of justice continuance, thus violating the Speedy Trial Act, warranting dismissal based on court violations. The Speedy Trial Act passes strict specificity requirements for ends of justice. The district court fails to comply with them. Whoa, that's a really long one. We're not going to read that one. No continuance period may be excluded from speedy trial computation. A continuance period is not excludable from speedy trial calculations. The trial court's failure to set forth in the record its reasons for finding by granting a continuance violates 18 U.S.C.A. Section 3161 through 3174. Bunch of letters and numbers there. The indictment time period violates the Speedy Trial Act. And the defendant's conviction will be reversed and the cause of remanded for dismissal of the indictment U.S. v. Perez Ravelas. On April 9, 2025, Judge Boreski in trial, which media networks aired his comment against the defendant. Oh, I remember this one. This is when I think Serena was testifying on the stand and Lori Vallow was starting to ask like all the religious questions. And there was an objection, but I think the judge made a comment. Oh, that's right. The judge said, I guess to the extent that you're comparing yourself to these biblical figures, I will allow it. So Lori Vallow complained about that. I remember reading it on stream with you guys. This was a malicious act by Judge Boreski to the defendant, manifesting discrimination and religious prosecution against Mrs. Daybell's religious exercise, beliefs, and practices under USCA Constitution Amendment 1st and the 5th due process. The comments compound the prejudice of an erroneous misunderstanding for the purpose of fundamental error. The defendant only needs to establish one prong to prove fundamental error. A judge who engages in improper behavior while on the bench is sanctioned. Oh, I wish we had a clip of it. Because she was asking Serena Sharp about these religious figures, and I forgot what their names were. I think Serena was kind of struggling and responding to Lori because Lori, I don't know. She's like, when she does the cross-examinations, it is confusing. And even though Serena was once within the realm of, being the, what's it called? In this religious group, sort of adjacent, maybe. Even she was a little confused. Like, what are you trying to ask me? Hey, Christine, how are you doing today? Happy Thursday. Hello. Candace, when they were deciding when to set both trials, she said that she would put the second trial past, speedy trial. He said, you can't do two at the same time unless you want to combine them. Gotcha. The good old Nephi, probably. It wasn't Nephi. It was another Some other religious figure. I have no fucking idea. No idea. Hey, love cats. How are you doing today? We are covering Lori Vallow. We're almost done. And then we're going to hop on over to Alexi Treviso and some of the documents we're going to be reading about. So that case, again, very interesting. The comments compound the prejudice of an erroneous misunderstanding for the purpose of fundamental error. The defendant only needs to establish one prong to prove that fundamental error. A judge who engages in improper behavior while on the bench is sanctions opposed. Oh, I already read this, my bad. Sanctions opposed, ARS Constitution Article 6.1, unprofessional conduct, violates ARS supplemental, I'm not really quite sure. Court rules, maybe? I'm guessing there. Duties and obligations of members. Under this rule, disqualification, 1, grounds a judge must recuse himself from any proceedings while a judge expresses opinions concerning merits of the proceeding or which the judge has a personal bias against a party. A judge violates due process by not recusing under 14th Amendment. The judicial decree does not justify public comment by a judge related to matter which is outside context of official proceedings. Plural, not plural. A judge's public comment, risk of appearing the judge impartiality and objectivity is compromised in violation of Canon 1, 2, and 3. The comment is order for dismissal. You know, when the judge made that comment, I don't remember Lori Vallow objecting to his comment. Did she? I don't think she did. I feel like she didn't really object a lot. Number 1, I am the defendant in the above entitled case. I am informed and believe, and based on the information and belief and allege that, again, this is Lori Vallow's affidavit, the Honorable Justin Boreski, the judge before whom this case is pending, has personal bias against me, Lori Daybell Vallow, in favor of the state. A judge who manifests bias or prejudice in the proceeding impairs the fairness of proceedings and brings the judiciary into disrepute. I guess it's like the opposite of like the reputation, I guess. Hey, Lauren Wilson, thank you so much. Member for 1 month. Hello. Thank you so much for your support. I appreciate that. How are you doing, Lauren? How's it going? You guys have any plans for summer? Is it officially summer already? I think so, right? I think we're done with spring. You guys have any summer plans or anything like that? A judge who manifests his bias or prejudice in a proceeding impairs the fairness of the proceedings and brings the judiciary into disrepute. Facial expressions, attitude, demeanor, and statements deprive the defendant of a fair and impartial hearing. ER 8.4, misconduct. Bias or prejudice of a judge shall not preside once affidavit is filed. The facts and the reasons for the belief that such bias or prejudice exists are statements of facts above, dated May 20th, 2025. So they had a hearing this morning, and it was in front of a different judge. I forgot what her name was. I think it was Judge Green, maybe, and motion denied. So they're going to continue with doing jury selection, or they're going to start jury selection this afternoon, continue into Friday, and then maybe next Monday we get into opening statements. Really? The summer officially began on June 20th? Wait, what? I thought it was before June 20th. Oh, wow. Vacate with family in July and then finishing my 2 ethics classes. Oh, nice. Where are you guys going for vacation? I'm just not looking forward to it being hot. I don't like hot. It's like, I love summertime, but oh my God, the mosquitoes, the heat, like, oh gosh. I just want it to be cloudy weather for a little bit, you know? Damn, it's already 105 in Arizona. Oh my goodness. Okay, so we have an Arizona trip that we want to do, but yeah, not in the middle of summertime. Not in the middle of summertime. So we want to meet in Arizona and have like a whole like dog trip and stuff like that. You know, maybe get a pool or something like that. But yeah, when does it start cooling down in Arizona? Like, should I wait until October or something like that? I would love to go back to Arizona. Which is pretty funny because the area that we usually visit in Arizona is where this whole shit is. It's like near Chandler, where Lori Vallow was living. Also in the Discord, I posted a 48 hours video where it was a case about a guy who lied about his identity, and he was with this Asian girl, and he ends up murdering her and then telling the family that like, oh, she just like up and left and went to Seattle. Obviously not, you know, he fucking killed her. But the interesting thing was that this happened back in 2010. So Juan Martinez was the one who prosecuted this case. And then Detective Moffitt, which I think is the same detective that was in the Lori Vallow case, because this was Chandler Police Department. he was on 48 hours as well. So I was like, oh my gosh, like all these people that like we've heard or seen of or that have testified on the stand, you know? So I posted in the Discord. It was kind of interesting. I'm late. Hi, Northwest. How are you doing today? Hello, hello. Oh, really? Was it on? Okay, I was trying to find it, but I didn't see anyone upload it yet. Thank you. Let's see. Fox 10. Did Lori argue? Lori Vallow preview with the expert panel. This is expert panel. Let's see. Where is it? Fox 10, Lori Vallow. Is it this one? Fox 10 Talks. This one has all their people talking. Where can I find the hearing? Is it on their YouTube or do they put it on their... Is it on their website? Fox 10. Let's do upload date. Maybe it's on their website. Da, 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 da. Yeah, I got my news from Nate Eaton. I think he missed the hearing though, unfortunately. Right when he heard about it, the hearing was already over. It's on YouTube? Where? I don't see it on YouTube. Fox 10. I typed in Fox 10 Lori Vallow. I see people talking about it, but I don't see the hearing. Fox 10. The Karen retrial. I am up to date with the Karen retrial, but oh my god, it is a lot. It is a lot. I personally think that the Commonwealth did way better than trial number 1. I think trial number 2 was a lot more cleaner, but damn, were there some fucking hiccups. I think has the state rest their case? I think the state has rest their case, and tomorrow is a half day, right? I think tomorrow's a half day, so the defense is probably going to argue to dismiss, and then afterwards, I'm sure that the defense will present their case maybe tomorrow or maybe on, let's see, maybe Monday, maybe. But yeah, we don't know who they're going to call first. They did, right? Okay, they rested today. Okay, yeah. Okay, under Lori Vallow trial preview with expert panel, Fox 10. Lori Vallow. Okay, I found it. But I don't see the hearing. Let's see, they're talking. Is the actual hearing here? Let's see, they're talking. Oh my god, what is this? Why is it so small? I found it. I thought I saw a tweet that he said that right here. We got 2 potential jurors in a row who advanced, a rare occurrence this afternoon. And then another one just advanced. Yay! All right, guys. So jury selection will continue this afternoon. And oh wait, that's right. We're in the same time zone. I keep thinking they're in East Coast, but no, they're not. I know where Arizona is, okay? But I'm just so used to trials being on the East Coast and, having a 3-hour time difference. But no, this is the same time difference. Okay. No, it wasn't Nephi. She was, she was trying to compare herself to a different, it wasn't Nephi. She was talking about other figures in the Mormon religion. The what now? They got bleach in the commissary? What are we talking about? Lori Vallow's hair or something? Yeah, I will have to say that she does have nice hair. She's got nice hair. All right, y'all. So tomorrow they're going to continue with jury selection, and then hopefully Monday they'll have opening statements. And yeah, that's it for today. I'm going to go eat because I'm starving, and I got to fix my background. I got like shit back here. You guys do not want to see. But anyways, guys, I appreciate you guys being here. Thank you so much for hanging out with us today. Earlier, we covered Lori Vallow's hearing and her motion for a new judge. And she wants Judge Boreski to recuse himself from all of her cases and also her upcoming attempted murder trial. That got denied. We watched a portion of the video because we didn't have the entirety of it. And then we moved on to Alexi Treviso and covered the Amici briefs, in which there was the ACLU. I always say UCLA, but ACLU, I got it right. And the, what's it called? Is it Obstetricians and Gynecologists Society or something like that, that were basically writing in support of Alexi Treviso and affirming the district court's decision to suppress evidence, which is statements that Alexi Treviso made in the presence of law enforcement, hospital staff, and her mom, and then also some of the body cam footages. And I don't know if the hallway surveillance camera was also included as well. But again, we are waiting for the decision of the Supreme Court. It's been quite a while. I don't know what's going on, but we'll keep tabs on it. And then we watched the rest of the Lori Vallow's the hearing in its entirety because the footage was finally uploaded onto YouTube. All right, guys. Well, I hope you guys have a good one. Take care. Feel free to join the Discord. You can have your notifications set on in Discord. That way you know when I go live, when new videos are out. And then also, yeah, thank you so much for hanging out here. Hit the like button if you guys enjoyed the stream, and I will see you guys later. I'm going to go eat. I'm so hungry. I'm starving, guys. Oh, and I read so much. My throat is starting to be like...